Sejam todos bem-vindos ao segundo webinário do SubConst, do Núcleo de Pesquisa em Subconstitucionalismo da Universidade Federal de Mato Grosso do Sul, coordenado por nós, por mim, professor Gisiela. No dia de hoje a gente recebe o professor Jonathan Marshfield da Universidade de Nebraska, Lincoln, Estados Unidos da América. Lembro a todos, para não deixarem de assinar a lista de presença que a gente vai disponibilizar da metade em diante do evento, ok? Dear Professor Marshfield, it's a pleasure to welcome you to the webinars of the Research Center on Subconstitutionalism, or SubConst, of the Federal University of Mato Grosso do Sul, that's based in Mato Grosso do Sul State, Brazil. Our research center exists since 2016, and since 2018 is dedicated specifically to researches in subconstitutional law and other fields like comparative constitutional law and federalism. This initiative, the SubConst webinars, are aimed to improve the activities of our center and improve the formation of our students and researchers. And we have received specialists and professors of several countries, such as Argentina, Brazil, Spain, Belgium, Italy. This year, we started with Professor Sergio Ferrari, from the Rio de Janeiro State University, Brazil, and with you in this webinar. And in coming months, we will receive speakers from France, Australia, Canada, and Spain. I will read a summary of a resume or curriculum, and I would like to say that we are very happy with your acceptance and generosity, and spend your time and share your knowledge with us in this afternoon. That will be a great opportunity of learning, ok? Pessoal, o professor Jonathan Marshfield é graduado em Direito pela Universidade de Nova York, doutor em Direito pela Rutgers University, de Nova Jersey, professor assistente do College Law da Universidade de Nebraska e foi professor da School of Law da Universidade do Arkansas. É autor de inúmeros trabalhos publicados em inúmeros periódicos especializados, como a Penn State Law Review, Michigan Law Review e outras. É advogado também com larga experiência em litígios cíveis em tribunais federais e estaduais nos Estados Unidos da América. Now, let's listen to Professor Jonathan Marshfield. Thank you, Professor.
Thank you, Fernando. Thank you for this invitation. I always learn an incredible amount when I'm able to interact with scholars from Brazil and with you in particular, so thank you. I've been to Brazil once, and I met Fernando on that trip, and I also met my favorite Brazilian friend, the Mr. Caipirinha. Did I pronounce it correctly? So I'm very happy to be here. Thank you. And just again, interrupt me if I am moving too fast or if you need a second. But I'm gonna share a little bit today about a very specific piece of research that I've been working on for about 2 years now. And the general issue that I am looking at is the extent to which constitutional rights in the United States operate differently under our national constitution than they do in the various different state constitutions.
Ok, I will translate, ok? A minha conferência de hoje está baseada em uma pesquisa de alguns anos e nós vamos tentar examinar como os direitos fundamentais operam de diferentes maneiras nos Estados Unidos, em nível federal e em nível estadual.
And I'll be very interested to hear from you all whether this is an issue that translates into other contexts or whether this is an issue that is a very sort of unique issue to the United States. Because the central problem that I'm investigating is that in the United States, constitutional rights within state constitutions are looked down on from the standpoint of constitutional theory.
Dos problemas principais que nós temos que examinar e que eu gostaria de saber, inclusive, como na vossa experiência, é exatamente o modo como os direitos fundamentais estaduais são vistos ou concebidos, porque na experiência norte-americana, muitas vezes os direitos fundamentais estaduais são vistos de cima para baixo, ou seja, de uma maneira um tanto quanto arrogante.
And the main reason that they're looked down on is because primarily they're a lot easier to change than the national constitution, the United States Constitution.
E uma das razões pelas quais eles são vistos assim é porque eles são muito mais fáceis de modificar do que aqueles direitos fundamentais que estão na Constituição Federal.
So under the United States Constitution, we have some rights protections that Americans tend to be very sort of proud of. Brown v. Board of Education is a famous decision in American desegregation history that held that under the national constitution and the Equal Protection Clause, the states and local governments were not allowed to separate schools by race.
Isso, em parte, é exatamente pela importância que os direitos fundamentais federais têm na história constitucional norte-americana. Por exemplo, Brown versus Board of Education of Topeka, que é de 1954, um importante precedente em matéria de direitos civis nos Estados Unidos, que acabou com a segregação racial nos Estados Unidos, foi baseada na 14ª emenda, ou seja, na Equal Protection Clause, que é uma norma federal.
When Brown was decided, it definitely had supporters within the country, but it was also a very unpopular opinion in many parts of the United States. And one of the reasons that the decision is celebrated now is because it stood notwithstanding great resistance from a large segment of the American population.
E embora tivesse apoiadores da decisão da Suprema Corte, tinha opiniões críticas a respeito dessa decisão, uma vez que ela não tinha uma unanimidade de apoiadores.
And so Brown has become sort of the paradigm for what a good US constitutional right should look like. It should help effectuate change, and it should be resistant to popular resistance.
Então, Brown acabou se tornando o ápice de uma pirâmide de como os direitos fundamentais federais têm que ser construídos, na medida em que ele tem que ser resistente, inclusive em face de uma resistência popular.
But state constitutional rights look very, very different, and they've performed very differently over time. And so, I'll tell you a bit of a story now that is in contrast to the story of Brown v. Board of Education.
Mas os direitos fundamentais estaduais, eles operam de uma maneira muito diferente nos Estados Unidos da América. E eu vou contar agora uma história para vocês a respeito da Brown versus Board of Education.
So in 1972, the California Supreme Court issued a decision under the California Bill of Rights, which held that the death penalty was unconstitutional and it could not be used in the state of California going forward.
Em 1972, a Suprema Corte do Estado da Califórnia proferiu uma decisão importante em que, com base na sua declaração de direitos estadual, entendeu como abolida a pena de morte naquele estado.
When that decision was made, there was 107 people in California who are currently on death row.
Quando aquela decisão foi tomada, havia 107 pessoas no corredor da morte na Califórnia.
One of them was Charles Manson, who had been involved in a series of grisly murders. If you saw Quentin Tarantino's movie of Once Upon a Time in Hollywood, there was his remake of those events.
Desses era Charles Manson, conhecido pela sua série de crimes violentos, né, homicídios, e sobre o qual o Quentin Tarantino fez um filme. Era desses condenados à morte que aguardava a execução.
Another person who was on death row was Ciron Ciron, who had been convicted of the assassination of Robert Kennedy.
Outra dessas pessoas era Ciron Ciron, o condenado pelo assassinato de John Kennedy.
As you can imagine, because of these two high-profile inmates, popular reaction to the Supreme Court's decision was very negative and very fast. And so there was almost immediate efforts to pass an amendment to the State Bill of Rights to undo the court's ruling.
Em função da alta impopularidade dessa decisão da Suprema Corte em face desse tipo de condenados estarem sendo livres da pena de morte em função da decisão da Suprema Corte, houve um imediato movimento no sentido, uma movimentação popular no sentido de aprovar uma emenda à Constituição para desconstituir a decisão da Suprema Corte.
And in fact, just 9 months after the court's ruling, there was a referendum on an amendment that was adopted by voters in California that reinstated the death penalty and said that the California court could never ever again rule that the death penalty was unconstitutional.
E, de fato, houve, apenas 9 meses depois, a aprovação de uma emenda constitucional por um referendo popular que restabeleceu a pena de morte no estado da Califórnia e, inclusive, acrescentou que a Suprema Corte não poderia jamais, em nenhuma circunstância, declarar a pena de morte inconstitucional naquele estado.
So it's stories like this that tend to dominate the criticism of state constitutional rights, because the concern is that if a constitutional right has any value at all, it should be able to stand up against impassioned popular majorities.
Esse tipo de situação que eu acabei de narrar gera uma falta de credibilidade ao direito constitucional estadual, tendo em vista que se entende que o direito constitucional deveria ser capaz de resistir a esse tipo de paixão popular.
And the truth is that state constitutional rights are just not very good at that. It's hard to look at the evidence and to conclude that state constitutional rights are effective at constraining motivated popular majorities.
E a realidade é que, de fato, existem poucas evidências que os direitos fundamentais estaduais são capazes, de alguma maneira, de constituir um constrangimento para as maiorias populares ocasionais.
And so in this research project, I have been trying to look at some of the original convention debates where state bills of rights were discussed and determine whether or not state bills of rights were intended to function in a way that was perhaps different than the way that the United States Constitution's Bill of Rights was intended to function.
Nesse projeto de pesquisa, nós buscamos identificar nos debates da Convenção Constituinte de que forma se concebia a operação das constituições estaduais. E, de fato, ao que parece, as constituições estaduais eram concebidas para funcionar de uma maneira diferente da Constituição Federal.
And I'll talk a little bit about my methodology and my findings in more detail, but let me give you my overall finding right up front.
Eu gostaria de falar um pouco sobre a metodologia e os resultados mais específicos, mas, em geral, eu vou falar, em princípio, dos meus resultados mais gerais.
So my overall conclusion is that although the Federal Bill of Rights has developed, for a variety of reasons, to operate as an important constraint on popular majorities, state bills of rights were actually never imagined to perform that function. Instead, state bills of rights have always been understood to kind of do the opposite. State bills of rights were actually built to help empower popular majorities to keep recalcitrant or corrupt government under popular control.
Ok. A minha conclusão geral nessa pesquisa foi que, diferentemente do rol federal de direitos fundamentais, os direitos fundamentais estaduais jamais foram concebidos para operar da mesma maneira. Em vez de serem limites para o poder da maioria, os direitos fundamentais presentes nas declarações de direitos estaduais, eles tinham mais o significado de ser elementos de uma construção de um controle popular sobre o governo, impedindo, por exemplo, governos corruptos, do que outra coisa.
And so what I'd like to do now is I will kind of divide the rest of my remarks into three sort of categories. I first want to talk about exactly how people in the United States have come to understand or misunderstand constitutional rights. And then I'll talk a little bit about my findings and what I think is a more nuanced and authentic understanding of constitutional rights. And then I'll say just a few words about what the implications of this might be.
Então, primeiramente, eu pretendo falar sobre alguns equívocos ou más compreensões a respeito dos direitos constitucionais estaduais, né, por parte das pessoas. Num segundo momento, falar um pouco dos resultados e tentar compreender melhor qual é a natureza desses direitos constitucionais estaduais. E, por fim, fazer algumas reflexões sobre as implicações desses resultados.
So, in order to understand the way that constitutional rights are supposed to operate, or at least the way most Americans think they're supposed to operate, we have to go back to James Madison and how James Madison conceptualized the Federal Bill of Rights back in the 1700s.
Então, em primeiro lugar, temos que pensar nos direitos fundamentais, tais como eles eram imaginados numa perspectiva madisoniana de controle da maioria, tal como James Madison imaginava eles no século XVIII, ou seja, nos anos 1700.
So Madison thought that if we needed a Bill of Rights for any reason, we needed a Bill of Rights to try and control against popular majorities that might use government at the expense of minorities and at the expense of society as a whole.
Então, o que Madison pensava era que nós precisávamos dos direitos fundamentais para limitar o poder das maiorias populares, uma vez que as maiorias populares poderiam tentar utilizar da sua força, da sua maioria, para, de certa maneira, impor suas regras ou seus pontos de vista para as minorias ou para toda a sociedade.
And so over time in the United States, Madison's fear of popular majorities has turned into a more complete theory of constitutional rights that has three key dimensions.
Ao longo do tempo, a perspectiva madisoniana, que concebe os direitos fundamentais como limitações para as maiorias, né, e a maioria popular, se desenvolveu numa teoria constitucional dos Estados Unidos que tem três dimensões principais.
The first important dimension is the idea of entrenchment. And here the idea is just that constitutional rights need to be beyond the reach of ordinary politics. They need to be hard to change so that the political branches and popular majorities don't have access to changing them when they would like to.
A primeira categoria é do entrenchment, que seria algo semelhante ao que a gente chama no Brasil de rigidez, ou seja, os direitos fundamentais e as normas constitucionais teriam que ser mais difíceis de ser modificadas exatamente para ficarem a salvo tanto da política ordinária quanto das maiorias populares ocasionais.
The next dimension is generality, and it's related to entrenchment. And the idea is that if we're going to make constitutional rights very hard to change, then we should focus on very general protections without a lot of detail. So we should focus on the things that really matter and that can be expressed generally. Things like freedom of speech, freedom of press, equal protection, due process, very general protections so that if they need to be adopted and changed, they won't have a lot of detail that would get in the way.
A segunda categoria, ou dimensão, é a generalidade, e está ligada com a categoria do entrenchment ou da rigidez. Se nós vamos criar direitos fundamentais que são extremamente rígidos, extremamente difíceis de serem modificados, nós não podemos ser muito detalhistas, nós temos que estabelecer apenas aqueles direitos mais essenciais, mais gerais, e não exagerar demais nos detalhes. Então, acabam sendo estabelecidos direitos como liberdade de expressão, liberdade de imprensa e outros, mas sem exagerar nos detalhes.
And then the last dimension is the courts. And the idea is that rights might need to be updated and they're going to need to be applied to specific circumstances. But if they're supposed to be entrenched beyond ordinary politics, the best branch of government for doing that is the courts. And so the courts are meant to help update, help improve, and help apply rights, and act as referees between political minorities and popular majorities and the popular branches of government.
E a terceira característica está relacionada com as cortes, né? As cortes eram vistas nesse contexto como o órgão principal pelo qual os direitos poderiam ser atualizados ou efetivados ou ampliados, né? De modo a proteger esses direitos em relação às maiorias, seja do parlamento, do legislativo ordinário, seja as maiorias populares. Então, esse papel caberia principalmente às cortes, ou seja, ao poder judiciário.
Now, if this is the dominant theory of constitutional rights in the United States, the data and just anecdotes make it very clear that state constitutional rights are dysfunctional because they don't meet any of these three important dimensions.
Então, se essa é a teoria dominante dos direitos fundamentais dos Estados Unidos, os dados sobre os direitos fundamentais estaduais mostram que eles são disfuncionais, porque eles não preenchem nenhum desses critérios ou eles não desempenham nenhuma dessas dimensões, como a pesquisa demonstra.
So if we look just at entrenchment to start, the United States Constitution has been amended 27 times since 1788. Not all of those amendments relate to the Bill of Rights. Probably only half or a little more than half of them relate to constitutional rights. But state constitutions, just current state constitutions, have been amended 348 times, and those amendments are just limited to state bills of rights.
Para que se possa ter uma ideia, só para falar da dimensão do entrenchment, ou da rigidez, a Constituição Federal foi emendada apenas 27 vezes entre 1788 e 2021, sendo que mais ou menos a metade ou pouco mais dessas emendas tinham a ver com o Bill of Rights. Comparativamente, se a gente examina as declarações de direitos estaduais, né, ou seja, os States Bill of Rights, essas foram emendadas só considerando as constituições vigentes atualmente 348 vezes entre 1970 e 2017.
And so state constitutions are obviously not very well entrenched, especially as it relates to the Bill of Rights, because they're amended very frequently.
Então, as constituições estaduais não são muito rígidas na medida em que elas são frequentemente alteradas, inclusive no que diz respeito aos Bill of Rights, ou seja, as declarações de direitos.
Likewise, if we talk about generality, the number of words in state bills of rights has increased dramatically and is significantly larger than the number of words that appear in the federal Bill of Rights.
Em segundo lugar, vamos falar sobre a generalidade. E o que se percebe é que o número de palavras cresceu drasticamente quando se examinam as declarações estaduais de direitos.
And then similarly, the amount of detail within those bills of rights with the increased number of words has increased quite a bit. So there's been a 43% increase in the scope of topics that are addressed in state bills of rights. And there's been a 116% increase in the level of detail that is used to address each one of those topics in state bills of rights.
Da mesma forma, quando se examinam outras variáveis, também se constata que a generalidade não é uma característica das declarações de direitos estaduais. Se constata um aumento de 43% no que diz respeito ao escopo substantivo, ou seja, as matérias que são objeto de normas de direitos fundamentais estaduais, e um aumento de 116% no nível de detalhes com que esses tópicos são regulados pelas constituições estaduais.
So unlike the federal Bill of Rights, which has remained relatively static over time and expresses rights in very general terms, state bills of rights have been amended a lot. They've increased in length, they've increased in scope, and they've increased in detail quite dramatically over time.
Então, diferentemente do rol federal de direitos fundamentais, que permaneceu estático e bastante genérico, as declarações de direitos estaduais, elas mudaram com muita frequência em função de processos de emenda e aumentaram drasticamente, tanto em termos de número de direitos, ou escopo dos direitos, quanto em termos de detalhes.
And then on the last dimension of courts, state constitutions are also sort of dysfunctional or fail because they are not well suited, nor have they been the source of great authority for courts on right issues.
E também no que diz respeito à proteção pelas cortes, existe uma disfunção, um mau funcionamento, na medida em que as cortes também não dispõem ou não gozam de uma grande autoridade em matéria de decisões relativas a direitos, as cortes estaduais.
And so I could just illustrate this with the story that I began the talk with, the People v. Anderson case, which basically involved the court making a decision and then the court's decision being overruled by an amendment.
E isso pode ser demonstrado pelo caso pelo qual nós começamos a conversar, em que uma emenda à Constituição do Estado da Califórnia revogou uma decisão da Suprema Corte daquele estado.
And in addition to that, there are many provisions in state bills of rights that courts have said are written in such a way that courts don't even know how to apply them to particular cases. And so state bills of rights are either subject to amendment so that courts are not really in control of them, or they're just written in ways that never give courts control in the first place. And these provisions are examples of provisions that courts have held are too vague for judicial application.
E também no que diz respeito a essas disposições, muitas constituições estaduais contêm provisões que não permitem uma aplicação direta ou imediata pelas cortes, e além disso, esses direitos presentes dos Bill of Rights estaduais estão sujeitos, em última análise, mediante o controle exercido por meio de emendas à Constituição, não às cortes, mas, na verdade, ao legislativo ou ao povo.
And so I conclude, as many other people have concluded, that if state constitutional rights are meant to operate in the same way as our federal Bill of Rights, then they probably are a failure because they fail to provide entrenchment, they fail to provide sufficient generality, and they fail to empower courts to decide rights issues.
Então, eu concluo no sentido de que se os direitos fundamentais estaduais são vocacionados a desempenhar a mesma função que os direitos fundamentais federais, eles falham nisso, na medida em que eles não têm a mesma rigidez que os direitos constitucionais federais, na medida em que eles não têm a mesma generalidade, na medida em que eles não são aplicados da maneira como os direitos constitucionais federais são aplicados pelas cortes para resolver problemas.
So this gets me to the second major part of my talk, because most other researchers have tended to stop after that first conclusion and have not looked very closely at state constitutional rights on their own terms to see if their behavior might actually indicate a different purpose for state bills of rights.
Eu vou além agora para a segunda parte da minha fala, porque a maioria dos estudos, das pesquisas feitas sobre esse assunto param nesse momento e não vão adiante, o que não permite perceber se, de fato, os direitos fundamentais estaduais não têm uma função diferente no sistema constitucional do que aquela que é ostentada pelos direitos constitucionais federais.
So what I did for this project was I drew upon some of the work that had been done by John Dinan before me, and I gathered all of the state constitutional convention debates that we have records for over history.
Então, o que eu fiz foi, a partir de um trabalho do John Dinan também, levantar todas as discussões das convenções constitucionais que criam ou alteram constituições nos Estados Unidos, dos quais existiam dados disponíveis.
John Dinan has identified 233 different conventions that have occurred over history, and he's been able to locate 114 debates for those 233. So 114 of the 233 have records from those debates. And I found those 114 as well and reviewed those.
John Dinan encontrou 233 convenções entre 1818, desde a origem, né? E foi possível encontrar os debates de 114 delas, né? Nesse gráfico encontram-se as 105 convenções, os debates das 105 convenções entre 1818 e 1984.
And when I reviewed those 114, I was looking for debates where the delegates discussed whether or not to have a state Bill of Rights and whether or not to modify a state Bill of Rights. And I found 105 of the 114 conventions where there was serious discussion of those topics.
O que foi possível encontrar foi que em 114 dessas convenções houve uma discussão significativa a respeito de se deveria ou não haver uma declaração de direitos estadual e se essa declaração de direitos estadual deveria ou não ser passível de ser alterada.
And these charts show the distribution of those 105 conventions. The map shows every state for which there was one serious discussion in a convention of the State Bill of Rights. And then the flow chart there shows where in time the convention debates were grouped.
Este mapa mostra em azul os estados onde houve uma discussão sobre essa questão, ou seja, se deveria haver uma declaração de direitos estadual e se ela deveria ser modificável ou não. E o gráfico em azul mostra em que períodos houve essas convenções, essas discussões ao longo do tempo.
And this information alone, I think, is very important because the model of constitutional rights that I described earlier derives primarily from the original US Constitutional Convention that occurred in the 1700s and that was dominated by James Madison and some others, as well as the 20th century civil rights cases that occurred during the civil rights movement.
Isso nos leva exatamente àquela discussão sobre o modelo sustentado por James Madison no século XVIII e sobre a discussão posterior envolvendo os direitos civis.
But these records show that Americans have debated how to use state constitutional rights across the entire country, and they've continued to debate it across the centuries through American history.
Mas isso demonstra que a discussão não se encerrou no século XVIII, mas que os americanos continuam discutindo isso por todo o país e que esse debate continuou ao longo dos séculos, não tendo se encerrado com a vitória da tese ou do modelo madisoniano no século XVIII.
And so after reviewing those records, I conclude that state constitutional rights are actually focused on a very different context, that they actually say some very different things than what the US Constitution says, and then that the delegates in these conventions actually practiced constitutional rights in a way that was very different than how Madison and subsequent federal scholars have practiced federal constitutional rights.
Então, o que se percebe é que existe um contexto muito diferente no qual operam esses direitos fundamentais estaduais do que os direitos fundamentais federais, que eles têm um conteúdo que parece ser diferente daqueles direitos fundamentais federais e que na sua aplicação prática também se verificam práticas no âmbito dos estados que são muito distintas daquelas preconizadas sob a perspectiva de James Madison e de todos os pensadores federalistas que o seguiram.
So first, for context, the state constitutional debates almost universally reveal that state delegates were not worried about the problem of majority faction the way that Madison was worried about it.
Então, o que o contexto demonstra é que os delegados nas convenções constituintes, diferentemente de Madison, não estavam preocupados com o risco de uma ditadura da maioria ou não estavam preocupados com limitar as decisões da maioria.
Instead, what the state debates reveal is that the delegates were most concerned about government officials that would abuse government power for their own gain at the expense of democratic majorities.
Pelo contrário, o que os debates nas convenções constituintes estaduais demonstram é que os delegados nessas convenções constituintes estavam preocupados muito mais com o abuso ou com a má conduta de agentes públicos que poderiam utilizar os seus cargos ou as suas posições em benefício próprio às custas da coletividade.
And so they discussed constitutional rights as a way to solve the problem of unfaithful government officials.
Então, eles discutiam nessas convenções as instituições constitucionais com maneiras de resolver o problema de governantes infiéis. Basicamente, era esse o problema com que se preocupavam os delegados nas convenções constituintes.
In the state debates, constitutional rights were meant to empower democratic majorities to control unfaithful government officials.
Nos debates estaduais, se tentava, na verdade, empoderar ou aumentar os poderes das maiorias para que elas fossem capazes de controlar a conduta de agentes públicos ou agentes políticos.
Another way to think of this is to use the phrase that was used in the Connecticut Convention of 1818, because the feel of the debates is that if there was one part of a constitution that was meant to be the most populist, it was the Bill of Rights. It was meant to be an ordinance of the people.
Uma frase que pode representar isso é da Convenção de 1818 de Connecticut, e que é conhecida como a mais populista, né, ou a que tem um vínculo, um viés mais popular, que é definida, que se autodefine como uma ordem do povo.
And so with this different context in mind, a lot of the text of state bills of rights makes a whole lot more sense.
Então, com esse contexto, uma grande parte dos textos constitucionais vão fazer muito mais sentido.
One of the provisions, for example, that is the most common in state bills of rights is like this provision from the Virginia Declaration of 1776, which talks about the right of the people to amend or alter government.
Então, uma das questões mais presentes nesses debates estaduais remonta a essa Declaração de Direitos da Virgínia, de 1776, ou seja, já da independência, e que diz respeito ao direito da maioria de alterar a forma de governo.
This provision is really at the core of how states understand constitutional rights differently than the United States Constitution, because it essentially describes the dominant right that was meant to govern and to control all other rights.
Então, essa frase, ou essa disposição da Declaração da Virgínia, ela parece ser o cerne daquilo que permeia o constitucionalismo estadual, que está muito mais preocupado em usar dos poderes, ou da maioria, para controlar o governo, do que como uma limitação do poder da maioria.
The State Bill of Rights was meant to be the place where the people would go to make sure that they were exerting control back over government.
As declarações de direitos são concebidas, as declarações estaduais de direitos são concebidas como o lugar principal na qual o povo encontra a sua capacidade de exercer algum controle sobre o governo.
And so this is also why state bills of rights end up having some very specific and very detailed provisions, because those details are responding to specific government failures.
E essa seria também uma razão pela qual as declarações de direitos estaduais seriam muito mais específicas e muito mais detalhadas, uma vez que esses detalhes ou essa especificidade estaria respondendo a específicos defeitos no governo.
So the last thing that I emphasize from my findings is the way that state delegates in the conventions actually practiced constitutional rights, because they practiced rights in a way that was very different from the federal understanding of rights.
O último aspecto que eu tenho que discutir é como os delegados nas convenções constituintes praticavam essa questão relativa aos direitos federais nas convenções, aos direitos fundamentais estaduais nas convenções constituintes, que era um modo muito diferente daquele que ocorria em âmbito federal.
So as I already mentioned, the state perspective is that the Bill of Rights is meant to be the place where the people reassert control over government.
Então, nesse contexto, as declarações estaduais de direito foram meios pelos quais o povo garantiria ter algum tipo de controle sobre o governo.
And so the debates reflect that from decade to decade, the people were picking all sorts of unusual and obscure issues, and they used rights to reassert their control over policy on those issues.
Então, os debates ao longo de décadas e décadas revelam que aquilo que era importante era exatamente essa tentativa do povo, de algum modo, conseguir ter instrumentos para exercer algum tipo de controle sobre os governantes.
And so there are literally hundreds of different issues, some which are familiar, some which are very obscure, that were discussed as rights issues in the state debates.
Então, existem centenas de assuntos, alguns mais conhecidos, outros mais obscuros, que acabavam sendo discutidos como problemas envolvendo direitos nessas convenções constituintes estaduais.
And what each of them held in common was that there was a disconnect between government policy and popular preferences.
E o que elas têm em comum é o fato de que existia uma desconexão entre aquela política governamental e as preferências da população nessas matérias.
Sometimes that disconnect had occurred because private groups had captured government.
Em alguns casos, essa desconexão acontecia porque alguns grupos de interesse privados conseguiam capturar o interesse público, ou seja, fazer com que o Estado agisse no seu próprio interesse.
Sometimes it was just because government officials were acting in very self-interested ways.
Em outros casos, isso ocorria porque os próprios agentes públicos agiam de maneira muito autointeressada e não no interesse comum ou da coletividade.
Sometimes it was because the way legislation was debated and compromised in the legislature produced a result that the people were unhappy with.
Em outros casos, isso acontecia porque o modo como a legislação era discutida e aprovada no processo legislativo acabava produzindo resultados que eram desconformes com os interesses ou com a vontade popular e causavam descontentamento popular.
And other times, just like the California case that I began with, it was because courts had reached decisions that the people were unhappy with.
Em outros casos, isso se dava exatamente porque existiam decisões proferidas pelos tribunais que causavam descontentamento popular.
But regardless of the reason, the state constitutional idea is that rights are a way for the people to reclaim policy.
Mas, independente de qual fosse o motivo da desconexão, no âmbito do pensamento constitucional estadual, os direitos eram vistos como meios pelos quais o povo poderia reivindicar novamente o poder político.
So, with these findings in mind, I think it's possible to change the model of constitutional rights that we've been using and construct a model that is more accurate and authentic for state constitutional rights.
Então, diante disso tudo, eu acredito que seja possível a gente deixar de utilizar esse modelo que a gente tem usado para pensar em direitos fundamentais, que é o modelo federal, e tentar desenvolver um modelo que seja autêntico para a compreensão dos direitos fundamentais estaduais e de sua função.
So the first thing that I would do, if I was going to talk about a state theory of constitutional rights in the United States, is I would scrap the idea of majority faction, and I would replace it with the concern about government recalcitrance.
Então, a primeira coisa que nós temos que fazer para criar uma teoria constitucional estadual nos Estados Unidos é substituir essa ideia de limitação da maioria e colocar em seu lugar uma noção de controle sobre uma recalcitrância do governo.
That's the core problem that state constitutional rights are focused on addressing.
Esta é a questão principal para a qual estão focados os direitos fundamentais estaduais.
And because that's the problem that they are focused on, they have different dimensions or different commitments than the federal theory of rights.
E em função desse foco, desse compromisso em resolver o problema da resistência do governo, eles têm dimensões ou elementos diferentes daqueles da teoria federal dos direitos.
So if rights are intended to empower popular majorities over government, then we need to get rid of entrenchment, and we need to replace entrenchment with some process that's going to empower popular majorities over government.
Então, se nós, em primeiro lugar, o caráter rígido tem que ser substituído, uma vez que os direitos são vistos como um mecanismo para melhorar o controle popular sobre o governo, não como elementos de limitação das maiorias, mas pelo contrário, portanto, rígidos, mas pelo contrário, como mecanismos que permitem uma intervenção e um controle popular sobre o governo.
And then we also need to get rid of a commitment to generality, because now what we want is whatever degree of specificity is necessary to realign government policy with popular preferences.
Nós também temos que nos livrar da ideia de generalidade, porque o que se deseja, na verdade, é qualquer grau de especificidade que seja necessário para alinhar a atuação do governo com as preferências populares.
And then lastly, we don't want to leave rights to the authority of courts entirely or ultimately. Instead, we want to make sure that the amendment processes which empower the people are the final decision makers on rights.
E, por fim, nós temos que substituir as cortes também, na medida que não vai ser a elas que vai ser confiado o papel que na teoria federal é confiado, mas, na verdade, ao povo que, mediante o poder de emenda às constituições estaduais, vai conseguir exercer o seu papel, a sua função de controle do governo.
Now, I think this represents a better understanding of how state constitutional rights have developed and how they continue to be practiced in the United States.
Então, esse é um modelo que eu considero que explica melhor como a teoria estadual dos direitos fundamentais se desenvolveu e como ela é de fato praticada no nível estadual nos Estados Unidos da América.
Now, I've spoken for quite a while, so I won't go on much longer, but I just want to say one or two things about the implications of this understanding of state constitutional rights.
Sem me alongar demais, porque existem vários aspectos, eu gostaria de falar sobre algumas possíveis implicações dessas constatações no que diz respeito aos direitos fundamentais estaduais.
The first thing I would say is that I'm not arguing that this is a normatively preferable way to do constitutional rights. And that was very clear to me in my findings, because this approach to constitutional rights has resulted in some really horrific decisions by states.
Então, um primeiro aspecto importante é que nós não estamos defendendo esse modelo de uma forma normativa, ou seja, como um modelo que deve ser seguido, mas nós estamos simplesmente descrevendo esses modelos e reconhecemos que muitas vezes esse modelo estadual levou a decisões terríveis no âmbito dos estados.
But for that very reason, I think that my findings are important, because American courts or US courts need to appreciate that constitutional rights in the United States can sometimes be doing very different things.
Mas eu penso que isso seja importante exatamente porque as cortes devem perceber que os direitos fundamentais nos Estados Unidos podem estar fazendo coisas muito diferentes em diferentes níveis, federal e estadual.
A protection under the federal constitution is probably working to provide guardrails or side constraints on democratic decision-making.
Os direitos fundamentais em nível federal, os direitos fundamentais do Bill of Rights federal, provavelmente estão atuando como uma espécie de guarda-corpo ou guarda-reios, evitando o excesso de poder, ou seja, servindo de uma limitação para o poder.
But that exact same right in a state constitution should be understood to be providing alignment between popular preferences and government policy.
Mas aquele mesmíssimo direito, quando previsto numa Constituição estadual, tem que ser compreendido como tentando prover um alinhamento entre a atuação do Estado ou a atuação do governo e as preferências populares.
And I think that has very important implications for how courts in the United States interpret state constitutional rights different from federal constitutional rights.
E isso pode ter uma importância crucial na medida sobre o modo como as cortes nos Estados Unidos devem interpretar direitos fundamentais federais ou direitos fundamentais estaduais.
But I will stop there because I would love to hear your thoughts and questions, and I don't want to overstay my welcome.
Eu vou parar por aqui porque eu gostaria de ouvir as suas impressões e discutir isso com vocês. Não gostaria de me alongar demais. Thank you so much, Professor. Incredible findings in your research. It's an amazing research. Congratulations. It's unpublished yet. Yes, Professor?
That's right. It's forthcoming in the Pennsylvania Law Review.
It will be a book?
No, it's going to be a long article.
A long article. Well, congratulations. It's amazing because it provides another vision completely different to the main vision of the paradigmatic conception of fundamental rights. I has read so many times that like there are a need of a federal constitution to limit the federal powers. There will be a need of state constitutions to limit state powers. And even of the importance or relevance of the state constitutional rights before the 14th Amendment, the Equal Protection Clause. And that these findings disconstructs these visions, these conceptions about the subnational constitutional law in the United States. It's very, very interesting, Professor.
Thank you. I appreciate that. And I should say that I apologize for all the times that I said America when I meant the United States, because I recognize that term refers to all of us, and it's but in writing to an audience in the United States, that phrase gets used very often. So I did not mean to disregard the important collective Americas.
There's not a problem at all. It's completely understandable, Professor. Your speech make me thought about the recall. The recall, it's an institution that I think that is originated in the Los Angeles legislation, the law of Los Angeles, and California, after in California, in other states. And it's an institution that represents very well this intention of control of the people over government. It's you find that there is a link between these institutions. There are other institutions that operates like recall or amendments in popular conventions in the states.
Yeah, absolutely. So the recall, the referendum on legislation, which is essentially like a recall for particular legislation, is, I think, in the same category as you're describing. And I one of the things that I'm trying to emphasize with this paper is that the recall and the referendum are often described as the product of the progressive era at the end of the 19th century and the beginning of the 20th century in the United States. And some of that's true, but much of what people were saying when they debated those institutions was they were citing back to these provisions in the state bills of rights, which said that the people have an inalienable right to alter, reform, or abolish their government. And that connection back to the Bill of Rights was conceptually right on point. I mean, these were in a sense just more specific ways and other specific ways to operationalize the commitment that was already really deep and that flew or grew and kind of fell out of a particular theory of rights, not just constitutions, but rights. So yeah, I mean, I think you're spot on, and it does connect back.
Okay. There is some institution like a judicial recall in United States also.
Yep. Yeah, not all states, but some states. Actually, California has the recall for their justices on the California Supreme Court, and so do some other states.
In Brazil, under Vargas in the 30s, authoritarian regime, we had an experience with a judicial recall of judicial decisions. Then, yes, a decision, judicial decision can be reviewed by a popular referendum. It's something incredible, because if the president was not in accordance with a decision of the Supreme Court, by example, he can submit that decision to a popular referendum that can maintain or overrule the Supreme Court decision. It was an authoritarian institution, but I don't know if you are if that is something like this in the history, in the constitutional history of the United States.
I'm pretty sure that it's never been implemented. It's possible that it was discussed. I've never heard of it though in the United States. I mean, it's a fascinating variation on the idea of recalling judges after the fact versus recalling specific decisions. What decade would that have? Is that an institution that's still present, or was it? It sounded like you were describing it as a. Okay.
In the 30s of the 20th century, under the Vargas regime, an authoritarian government.
Was it used?
What?
Did they use it? Did they ever do a referendum?
A few times, two or three times. Maybe I can share the information with you later. I can make the research and provide you the informations two or three times if I not made a mistake. If I not made pessoal, alguém tem alguma pergunta? I will I will ask for questions to the audience. Pessoal, alguém tem alguma pergunta que gostaria de fazer ao professor Marshfield sobre a fala dele? Se tiverem, fiquem à vontade. Vocês podem me fazer a pergunta aqui, verbalmente eu traduzo, ou se preferirem, vocês podem fazer a pergunta diretamente a ele, ou se vocês preferirem, vocês podem também fazer a pergunta pelo chat, que nós fazemos a leitura para o professor, né? Eu acho que é uma fala bem interessante dele. Fiquem à vontade, não sejam acanhados, ok? Professor Marshfield, I already read about this decision of this amendment in the California Constitution to overrule a decision of the California Supreme Court, and I don't understand it when I read what are the reasons. And with your explanation, it's been much more easy to understand why was so intense the movimentation to overrule that particular decision. There are other cases of revision of the decisions of the state Supreme Courts by popular amendment of the constitutions in other states than California.
Yes, there are. It's quite a frequent pattern. There's been all sorts of attempts. So the marriage, we had some early state constitutional rulings on equal protection as it related to the right to marry. And so back in the early 2000s, there was some decisions that were based on sexual orientation and the right to marry based on sexual orientation. And those decisions triggered a bunch of responsive amendments. Some of those amendments were responding to rulings in those states. Some of them were responding to rulings in other states that people anticipated were coming. But that's an example. There's other examples from the desegregation era. So there were some state court rulings on things like busing. So again, I'm not sure how many of these factual situations are unique to the United States, but when the schools were integrated by race, part of the problem became that everybody lived by law in separate communities. So if you just let people go to school in their community, things would stay segregated. So there were some initiatives to bus people into different communities to try and make sure that schools were integrated. And state courts made those rulings based on equal protection, and some states passed amendments that overturned those rulings. And so there's quite a long history of amendments that overrule. And John Dinan has an article that collects a lot of them in one place.
Okay, thank you. Professor, how can we interpret, make the interpretation of the Equal Amendment, the Equal Protection Amendment, the 14th Amendment, in this context of the findings of your research? There is a change of meaning, or this confirms that the main role of the Federal Bill of Rights is to limit the power both of the union, of federal and states power, and the State Bill of Rights fulfill another role in the total constitutional system of the United States?
Yeah, it's a really good question, because one of the tricky things is that the model that I describe as characterizing our federal constitution developed over the decades. And one of the important moments that helped it develop was the 14th Amendment, because without the 14th Amendment, the model really doesn't come into sort of full focus. So yes, I think that the 14th Amendment was critical. Madison was really worried about majority faction, but at the time of founding, he didn't have the 14th Amendment, nor did he have the full power of judicial review established. And so I don't think that he would chart the model the way that I did. I don't think that it was fully formed yet. But with time, with Marbury v. Madison, which sets up judicial review, and then with the 14th Amendment that comes on and gives the federal courts authority over states, as those pieces fall into place, that's what the model sort of comes to represent.
Okay. Yes.
No, I guess I would also say the other critical piece is that Madison was correct. In many of the American states, there were very mean, very hateful, very horrible majorities that needed to be constrained. And so it's not that Madison was wrong. It's, his fear was a real fear. It's just that the states had another fear that they were using rights to address.
The states are laboratories that proves in many cases that the fears of medicine has a reason to exist.
Yeah.
And I think that sometimes we read in that the federal constitution of the United States are a Madisonian constitution, and the state constitutions are Jeffersonian constitutions. It's right to think like this on the findings of our research. What do you think about this?
Yeah, it's interesting. I think that there's a lot of similarity with Jefferson's ideas and how state constitutions have developed. but I also think it's true that the states have remained independent laboratories of constitutional thought, which means that they've developed details and they've developed ideas that are beyond what Jefferson, I think, would have originally imagined. And so yes, I think that's a good contrast, right? The states are much, I guess I would say it this way. The states have become much more Jeffersonian than they have Madisonian. I think that's true. I think that's very true.
Okay. In how we can understand the Brennan statement about the role of the state Bill of Rights and the idea of new judicial federalism that seems to me to be related with the conception of Justice Brennan. There are some impact of your findings in your research on the traditional vision about the conception of Brennan, for example.
Yeah, I think there are. I think I disagree with Justice Brennan respectfully, that he was equating federal rights and state rights as if they were both the same fruit. They were just in different jurisdictions. To him, they were the same thing. It's just that one was in the power of state judges and one was in the power of federal judges. And so he basically says, when we federal judges do something, you state judges can do something else. And I don't think that's an accurate understanding of what's going on, because it's not state judges versus federal judges. It's federal judges versus the people of the state, because they're the ones that have always maintained control over the rights. And so, you know, he's obviously correct as a matter of doctrine. State judges do not have to follow what federal judges do. But as a matter of theory, I don't think that's the relevant question, right? It's sort of like, sure, you don't have to, but if you do something different than what your constituents want you to do, then what you do is not going to matter at all. And that's different for a federal judge. Federal judges, that's not the same. They're not interpreting the same sort of thing as the state judges are.
Understand. And sometimes we read also excellent works like Looking for Rights in All the Wrong Places from Emily Zakin. I think that is that the pronounce correct, Zakin, that insists that the subnational constitutionalism in the United States affirms the theory of the exceptionalism of the constitutionalism, North American constitutionalism, and you see an impact over this kind of work.
Yeah, it's fantastic. I mean, I think so. Emily Zakin is, she's a political scientist, and so she knows a lot more than I do about politics. And her work, I think, runs parallel to what I have been doing and to this project. Her ultimate conclusion, I think, is that political scientists have viewed rights as benefiting entrenched elites, right? Like that's what rights do, is because they preserve the status quo. And she sort of shows that rights can do something else. And I generally agree with her findings. And then what I want to emphasize, though, is that it's not just the product of politics, which is what she focuses on. She focuses on how outside groups have been able to gain access to constitutional rights. I'm trying to say, yeah, the reason that they've gained access is because that was the theoretical design of those rights sort of from the beginning, right? It's not just that these outside political groups had power. That's part of it, but it's also because the actual design of the institution was conceptualized that way by state constitutionalists. And so that's the legal theory, I guess, side of it that I am trying to pull out of the convention debates. But yeah, no, I think Emily Zakin couldn't be more correct. I think she's spot on with how she's described state constitutional rights.
Then the works are complementary in
Yeah.
some sense.
Yeah.
Yes, incredible. I think that I will do some changings in my next lessons of subnational constitutional law because
well, me too, especially your reference to. I need to go and just research is it the De Vargas? Was that the regime? Yeah.
I will send you some information, Professor. I promise. But I have so much to think after your speech. Very interesting findings. I will ask one more time for questions. Pessoal, alguém tem alguma pergunta? Renata? Olá, tudo bem, Renata?
Oi,
Renata?
professor, tudo bem? Hi, Professor Jonathan. How are
Hi,
you?
I'm well. How are you?
I'm talking from Sevilla. I'm here to research in university, and I'm like fellow old researcher from the big project from Professor Luis Fernando. And I want to make a question, if it's possible.
Of course.
So your research is very particular, complementary of the question of stability in countries that we have not a centralization. That's it. Professor Luis Fernando talked about our reality in Brazil, but we have different realities in the kind of constitutional rights of South America. And I want to explain to us like more the differences between recall and impeachment, because we have recall in Venezuela, also I think so in Peru and some of other countries. But I hear that I research not a lot, but here in Spain, they are arguing about the limits of this kind of tools that people could manage the control of the significance of representation. And there is an example of Constitution of Weimar that I can't pronounce because it's German. It's a big word that's the kind of some like impeachment. And we have impeachment it's familiar for us, and recall that we have in some countries in South America, but it's kind of, punctual. And we have a big example in the United States. And here in Spain, they discuss a lot of it. If it's possible, we have a recall directly here, because for them it's kind of some more democratic way. Because in impeachment, we have a procedure that the politicians do with themselves. You don't have this kind of direct representation. So my question is that you can talk more about it and this difference between them, and your opinion about this. If this is that really a more democratic tool for the constitutional control or not. That's it. And thank you for your presentation today. For me, being here, it's kind of a huge pleasure, because Professor Luis Fernando is, kind of a mentor for me. So thank you. That is my question for today.
Thanks. That's a great question. And whenever I do these, I learn so much. And just the idea that there's a debate going on in South America about the legal scope, it sounds like the legal scope of these different democratic mechanisms like recall, impeachment, is fascinating, because, well, I don't have to tell you that we in the United States tend to be very provincial, and it limits our ability to learn. And so this is great just to hear from you that that's ongoing, because I need to find that stuff and learn about it myself. I don't know what I could offer that would translate to those discussions, because I don't know the issues. But I mean, I could provide a little bit of the description of what those different mechanisms mean in the United States and to people within the United States. And it actually sounds to me like you already have a good grasp on that understanding. The biggest distinction between impeachment and recall in the United States is that impeachment is still heavily dependent upon representative government, right? Like just the idea to impeach somebody is a decision that's made by representatives, and it's intended to be made by representatives. And so that triggers all of the problems or all of the protections, depending on your perspective, that come with representative government. So if you're concerned about populist democracy, then it's a good thing, because before you can impeach an officer or an agent, all of the sort of debate and dialogue and compromise that goes on behind closed doors in representative government is going to protect against a populist impeachment. If you think that all of that debate and dialogue is really just corruption, and then, you know, it's frustrating because impeachment doesn't actually get you anywhere, right? And I think that most people in the United States believe that, at least at the federal level, impeachment has become captured by partisan politics, right? It's not about true democratic accountability. It's a tool that the parties use to leverage things, right? And so even to the point where you could be successfully impeached, but then there's a whole separate round of partisan politics about what the consequence or the sentence of impeachment would be, right? Like, if you really care about popular accountability, breaking it up that many times is just so infuriating, right? And so I guess that's my perspective on impeachment. Now, recall, I think, is intended and in fact does operate in a much more populist way. In the states where it's being used, there's increasingly concerns that the campaigns are being ignited by the parties themselves, and so that it's subject to the same problems, right? So when we have a recall in California, it's not because Californians are really motivated. It's because the party that's not in power senses a vulnerability, and they put tons of money into a recall to try and stick it to the guy from the other party, right? Like, that's really what's driving recalls. And so there's concern that it doesn't have the same grassroots accountability anymore that it was intended to. Now, my perspective is that, you know, it still requires an actual citizen vote on the recall, right? And so it's subject to manipulation, but I don't know what else we can do other than vote on things. Like, I don't know what else we can do. And so it might be subject to manipulation, but at some point I just have to believe that we can trust voters, or we have to just throw the whole thing to the wind and just be like, we're screwed, we can't do this anymore. So I guess I would tend to believe that the recall is more likely to produce popular accountability than impeachment. But I think America provides examples that go both ways. So it's a really interesting question.
Thank you, Professor Jonathan.
Thank
And
you,
just to
Professor.
add, the countries that we have recalled recently, I asked to my professor here in Sevilla, and it's Ecuador and Bolivia. They have changed in like 2009, something like this. And my professor just responded me that is the latest change in America that we have close to United States reality. So thank you, Professor.
Yeah, sure. And those are national, those would be national recalls for national officials?
My professor said this is national, but the government in Ecuador and Bolivia have some kind of regional constitutionalism, different from Brazil, you know? So
Okay.
they can apply to the subconstitutional way, but with other lines, different from United States, because don't have the separate power like in Spain too, but you can use some tools to manage that we don't have in Brazil, for example, because we are, you know, submitted to the federal power in a lot of ways of power of states and control and Supreme Court and everything else.
Okay.
So they said in short lines that is a kind of recall. It's similar, but not the same way, because they don't have this kind of subconstitutional empowerment, don't have this, reality that you have in the United States, that Spain have in some way, because they have here some autonomous, litigation of things and power. Not the same too. I'm learning now about it. It's different from Portugal, it's different from United States, it's different from anywhere else, but it's the more closest way of recall that have recently by my professor Ramon said now.
Interesting.
Yes.
Thank you.
I think that the main aspect in the speak of Renata is that only 4 countries in Latin America are federations. Then some of these countries are regional states at the best, and then the degree of the autonomy, subnational autonomy, is diverse. Renata was my former student in the graduation and in the master in law, and actually he is in made the Juris Doctor PhD in Portugal and Coimbra University, and he is in this moment in Sevilla, Spain, where she made some researches. Thank you once again, Renata and Professor Marshfield. There is a question in the chat. I will try to translate to you, Professor, if we have already time. I don't want to
Maybe one more. I need to be on another call at 3:30 our time. So
I'm so sorry for my fault also. The question is like this. We can say that this inversion of the roles of the state constitutions, protection of the majority, or provide the instruments to the majority control government, will be a direct consequence of the process of formation of the United States or of the American Federation, or no? There is any relation, in your opinion, between the formation of the United States from the 13 original colonies and the peculiar or particular role developed by the state constitutions, or the different conception of the state constitutions? Difficult question, eh? Jesus
yeah,
Gomes.
really good question. And it's, so I do think that the paths were very different. And when you read the original materials in the states, the paths stay very independent. The problem is that Madison and a bunch of other people started cherry picking material from the states in order to make arguments about what the federal constitution should and should not do. So they were always picking on what was going on in the states as a way to illustrate usually how you should not do things at the federal level. Since that time, my sense is that people have kind of assumed that the Madisonian perspective on the states was like locked in time, and that's the dominant sort of idea. And the states just continued, I think, independently doing things very differently. And so the states, I think, impacted the federal constitution as a way of providing counterexamples at the time of founding. But then after that, I feel like the states were very independent in how they thought about their constitutions. At least that's the feeling that I get when I read the debates from decade after decade after decade. They weren't ignorant of what was happening at the federal level or how the federal constitution operated, but they were very aware of the independence they had to do things differently. And then to the extent the question is also pointing out that you can't do majoritarianism without the protection of like equality so that everybody gets an equal say, because to get a majority, you've got to add things up, right? And you got to know who gets to be added up to figure out what the majority is. And that's a very real problem. And the federal constitution and the federal perspective on rights has evolved over time to help the states form more legitimate majorities. And so I do think that like the model that I'm describing, to some extent, it exists as a luxury because of how the federal constitution has developed. And so if that's what the question is getting at too, I think it's a really insightful question, and I agree. I think that the states are lucky, right? The states are fortunate that they have this strong protection for certain things so they can do what they do. And Tom Ginsburg at Chicago, I think, has made this point about the United States. He's also made it more comparatively too. So,
okay. Professor,
I'm sorry I cut short, but
sorry, please.
I was just saying I'm sorry that I have to cut short and run.
Yes. I thank you very much. It was very productive. We learned a lot. Thank you so much. And sorry, my mistake with the time.
No problem. I'm very honored and I'm very grateful for being able to talk with you guys. So thank you so much for taking your time to chat about these things. I appreciate it.
Thank you, Professor.
Yep.
Bye. See you soon at Recife, at Conferência.
Yes, I would love it.
Bye.
Bye.